Mr. Sperry.
Your Honor.
All right. Mr. Sperry, before we start, let me raise something with you that affects our jurisdiction in the case.
Yes.
Apparently, there is an unresolved motion for rehearing that was filed below,
Yes, Your Honor.
which makes the notice of appeal in this case premature under the rules. We don't have our jurisdiction is inchoate at this point. So we have, it's typically in our practice has been when this comes to our attention late in the process, we allow the argument to go forward, but we can't decide the case until you get a signed written order filed disposing of that motion for rehearing, or you file a written withdrawal of the motion in the lower
Yes, Your Honor. Yes.
So
my intention would be to go ahead and withdraw that motion. I will file that.
okay, and shoot a copy our way. Let us know that you have done this.
Yes,
File a copy with our clerk to give notice that you filed that.
Okay.
All right. Okay, you're up.
Thank you, Your Honors. I would like to reserve 5 minutes, if I may.
Sure.
May it please the court. As was acknowledged, I represent the appellants Ellsbury's in this case, and this court action and appeal involves 3 documents. One is a 1996 Clark to Clark quitclaim deed that was given from parents to a child out of love and affection, a 2004 Clark to Carpenter easement. There is a dispute as to whether there was material consideration, and then another 2006 Clark to Clark quitclaim deed, which was also given out of love and affection. Appellants believe that the case and the appeal rest upon whether the lower court properly concluded that the 2006 Clark to Clark quitclaim deed could relate back and reform the 1996 Clark to Clark quitclaim deed. Especially,
was it not labeled as a corrective deed?
It was labeled corrective
and recorded,
Your Honor,
before your client received your client received the property.
That is correct, Your Honor. However, we believe that because both of those deeds were quitclaim deeds given out of love and affection without any material consideration,
between a parent, the deeds were from parent to child?
It is parent to child.
Okay.
And there are affidavits in the record establishing with both of those deeds. The second deed, one of Mr. Clark's parents had deceased, so it was only from the surviving parent at that time. As for the 2004 Clark to Carpenter easement, there are no errors within that document that need to be reformed, while the lower court did indicate reformation. Further, the lower court found that there was consideration to the extent that consideration was significant in the ruling and in this court's consideration. It would be improper to enter summary judgment because there is conflicting testimony. Mr. Clark has an affidavit that he gave that was given to Mr. Carpenter or the Carpenters without any material consideration, while the appellee relies upon a form, an easement form that says $1 of consideration, and the testimony and the evidence is that Mr. Carpenter alleges that the material consideration was in fact that $1. So we submit that it's undisputed the property was given by parents to their son out of love and affection without material consideration, and that becomes significant based upon that's the law in the state of Florida dealing with deeds given out of love and affection. So these additional lands in 2006 do not encompass lands, do encompass the lands in the 2004 quick easement. Obviously, they were not in the 1996 deed. To the point that there was an error, the lower court specifically found at the time the Clark Carpenter easement document was executed and recorded, Bruce Clark did not lawfully own the property subject to the easement. So there is a conveyance in 2004 of an easement. There's no dispute that Mr. Clark did not own it at the time. Then the question then is that to the extent there was a mistake in the legal description in 1996, because it was a gift from parents to child without any consideration or love and affection, no material consideration, then the law is clear that becomes if there was a mistake, it was a unilateral mistake. As such, a reformation of the deed would not be available because a unilateral mistake is not a mistake that can be otherwise reformed or in any fashion. It's the lack of material consideration that is fatal to the
I
argument.
acknowledge, though, that a corrective deed is not a reformation of the deed. It's just a correction of a deed.
Well, in this case,
But
Your
make
Honor,
the deed reflect what it should have reflected at the time.
if I may respond, even though it says corrective deed, it is a quitclaim deed. It is a deed that's given out of love and affection. And more importantly, the 1996 deed was given out of love and affection, no material consideration. As such, reformation of that deed cannot occur under Florida law because it was at best a unilateral mistake. And you can't, and plus it's a quitclaim deed. You get what you get. So the two deeds, there was land conveyed in 1996, and there were additional lands conveyed in 2006. I do not believe the law in the state of Florida, the Supreme Court decisions, which I'll get to later, is that when you have a gifted deed, it's at best a unilateral mistake. And that unilateral mistake cannot be reformed. What we're doing is we're reforming a 1996 deed.
So, Mr. Sperry,
Yes, sir.
just going back to Judge Northcutt's question, is there a distinction between reforming a deed and correcting a deed?
Well, because
your argument has focused on the problems with reformation, but
correct.
there is such a concept as correcting a deed, issuing a corrective deed. And so is there any overlap between the elements as far as what would preclude a reformation versus what would preclude a correction?
I don't believe that there's any distinction between the two. If in fact you are correcting a deed, and in a normal situation, you would have typically be a deed with consideration, lots of times warranty deeds, which the cases cited by the lower court are such. But what we're doing is that if you're going to correct a deed, in this case, 10 years later, you do a corrective deed, what they're looking for, what the court found is it relates back. If it relates back, then you're reforming the original legal description in the 1996 deed to reflect what is in the 2006.
Let's assume, for the sake of argument, let's assume that we believe this is capable of correction versus reformation. If we believe that, then wouldn't your client's position be a loser in this case because the corrective deed was recorded years before your client acquired the property?
I don't believe so, Your Honor. So what I believe happened with the corrective deed is in 2006, when that quitclaim deed without consideration was recorded, the correction occurred at that time because new lands were added to the deed. So what happened in 2006, Bruce Clark acquired more property than he had in 1996. I don't believe, because what you have to do to reform and relate back, those standards have not been met. So too, if you look at constructive notice, these same documents in 2004 were available to Mr. Carpenter. Whether they did a title search, whatever their due diligence revealed and not revealed, in 2004, the 1996 deed was of record. It had a legal description. In 2004, this easement had a legal description. The legal description within the easement was not contained in the 1996 deed. So too, they were also on notice that the easement that they're getting did not contain the legal description that Mr. Clark, Bruce Clark, did not own the land that was described within the easement, because the same documents are of record, and that's constructive notice to the Carpenters as well. Continue on. So I think what we have here is if we look at the lower court's ruling, she believed that she was reaching a just conclusion. She specifically says notions of fair play and justice require reformation of the Carpenter easement, and the same principles apply to the 1996 deed. So first of all, the Carpenter deed would not be reformed. That was an error, but the 1996 deed should not be. Notions of fair play should not trump the well-established law memorialized by the Florida Supreme Court in Providence Square Association, Inc. versus Biancardi and the Treesback-Tyler decision. Both of those deeds gratuitously given constitute a unilateral act on the part of the grantor, and equity, and reformation is equity, equity will not decree reformation on the ground of because a mutual mistake is not present. The general rule is summed up in the Providence Square decision, where a deed is given gratuitously and thereby constitutes a unilateral act on the part of the grantor, or where the only consideration is love and affection rather than material value, equity will not decree reformation on the ground of a mistake. On the other hand, and when I say mistake, you mentioned corrective deed. Corrective deed would suggest that something was left out. On the other hand, a deed given pursuant to valuable consideration is normally the result of some degree of bargaining and is therefore bilateral in character. Since in this case, we have a gift, and a gift is never to be subject to reformation, because the purpose of reformation is to correctly reflect the intent of the parties to an agreement. And with a gift, there is no agreement, and that's the Dro 15R LLC case. So a donor's intent in making gratuitous promise to make a gift or any mistake in attempting to effectuate the donative intent is not a proper subject for legal inquiry and relief, because a gratuitous promise to make a gift does not constitute a contract. And let's not forget that we are dealing with quitclaim deeds, not warranty deeds. And in the Goldtrab-Bryan decision, the 1955 Florida Supreme Court case, a conveyance which was made by quitclaim deed does not amount to a repudiation of the former deed. This is true because the very nature of a quitclaim deed, whose execution without more, does not necessarily import that the grantor possesses any interest at all. Bruce Clark acquired a set amount of lands in 1996, as described in that deed, from his parents as a gift. Then he acquired these additional lands in 2006, also a gift from his surviving parent. So we have two deeds, two separate conveyances of, well, it incorporates prior lands, but we have two separate deeds, two separate conveyances. Unfortunately for the Carpenters, their due diligence, I mentioned before, did not reveal, or they didn't bother to verify what the conveyances are. So when we're dealing with the potential or the order of the lower court, where they reformed the 1996 quitclaim deed, it is not available because A, the deed being gratuitous would only constitute a unilateral mistake, and that cannot be reformed. And that's the Supreme Court decision in Providence Square Association. And second, As in Brown v. Brown, it's a 50 DCA case cited in my brief, a gift is never subject to reformation because the purpose of reformation is to correctly reflect the intent of the parties to an agreement. And with a gift, there is no agreement. Had this easement occurred possibly in 2007, we wouldn't have the problem. Or if this mistake had been brought to someone's attention, if it was in fact a mistake. But at this point in time we only have the documents that we have, and those are the quitclaim deeds and the easement. If we're looking at the easement and there's some decision that that's being reformed, I don't know how it can be reformed because it's correct. But if you're dealing with consideration, the lower court made a determination that there was consideration when that was in dispute. There is no dispute that the 1996 deed and the 2006 deed were out of love and affection, and there was no material consideration. So
you're coming into your 5 minutes rebuttal time, so use the minutes as you please.
Okay, I'll stop right now and conclude later, Your Honor.
Okay. All right, Mr. Appley, you're up.
Thank you, Your Honors. May it please the court. Jason Nazarone, I am here on behalf of Mr. Moore, who is the personal representative of the estate of Charles Carpenter. As the court is aware, Mr. Carpenter passed during the pendency of this appeal. There's a couple things I'd like to start out with that are glaring omissions by the appellant in this case. The first one being he's made many references in the brief and today about there being undisputed evidence, and undisputed evidence. There is no transcript from the hearing on the summary judgment in this case. So to the extent that counsel attempts to argue what the documents show, what the documents say, that's argument of counsel. We don't know what was actually presented to the trial court. We don't know what the court's questions were.
Both sides moved for summary judgment here, correct?
That is correct, Your Honor. That is correct.
So
However,
both sides contended that there were no material issues of fact.
that is correct. I'm saying for this court's review, if there are questions as to what the trial court may or may not have done, the absence of a transcript from the hearing could impact Your Honor's decision. That's just something I wanted to bring up that wasn't really addressed in either the initial brief or the reply brief. The second thing I wanted to bring up is the lack of any argument, acknowledgement by the other side of the Golden versus Hayes case. Now, in the court's order, it said the trial court specifically said, and I'm looking, is that they found that the Golden case was on point. She found that, it said paragraph 18, page 278 of the record, the court agrees with Mr. Carpenter that Golden v. Hayes 277 Southern 2nd 816 is directly on point. There's no argument in the initial brief countering this. There's no argument in the reply brief countering this. And the reason is that the case is exactly on point. And it kind of goes into what Judge Silverman was asking of the appellant. If this court believes that the deed could be corrected, does the appellant lose? And the answer is emphatically yes, the appellant loses, because that's what a corrective deed does. A corrective deed goes back and corrects an error. There is confusion as I read the cases, because a lot of courts say that a corrective deed reforms. That leads to the belief that there's a reformation, and most of the arguments raised by the appellant in the initial brief, in the reply brief, talk about reformation actions. And what counsel has tried to do throughout this case is apply the elements of a reformation action to a corrective deed. And the case law it's very clear that parties where they discover some type of an error of something that wasn't done correctly, the first way to do it is, hey, we're going to agree, we're going to execute a corrective deed. All that needs to do is be recorded, and then it's deemed to relate back and read together with the initial deed. So in this case, what you have is you have a corrective deed where the parties realize there's an issue, they agree there's an issue, They go back and correct that issue. Land wasn't conveyed. There wasn't new land brought into this. What happened was the corrected deed went back, and then that goes back to the 1996 deed. Once that's corrected, then the easement is proper and goes forward. And that's exactly what the trial court found in this case. And there really isn't any argument by the appellant as to why this isn't right, outside of using the elements and case law for a cause of action for reformation, which is, to Judge Northcutt's question, a distinction. It is different. And I think that's kind of the argument where the appellants fail in this case. If we look at the case law on whether you can have a gratuitous transfer, I cited case law in my answer brief that goes to the point that you can have a gratuitous transfer and you can still have a corrective deed. So it's our position that the lower court was not erroneous in granting summary judgment. And if there are no further questions from the court, I will yield the rest of my time. We would just ask that the court affirm the summary judgment of the lower court.
Thank you, Mr. Azzarone. Okay, Mr. Sperry, you're up to rebut.
Okay, thank you, Your Honor. First of all, I would note that there were claims for reformation brought by the appellee in the lower court of the deeds, and as well as the easement, and for which the lower court found reformation was to be appropriate. Regarding evidence of love and affection, there are affidavits of both of Bruce Clark as to both of the transactions, so that is undisputed evidence that they were out of love and affection. Regarding the Golden v. Hayes, I believe it was addressed, and that's to be distinguished from the cases, this case, because it's clear that that was a warranty deed and that there was material consideration. I would suggest to the court that if these deeds were warranty deeds and had material consideration, we would not have this appeal. This appeal addresses the fact that the deeds we're dealing with were out of quitclaim deeds out of love and affection. What we have is in a corrective deed.
Does Golden rely on the fact that it's a warranty deed? Because the language in Golden seems to be much broader than linking it specifically to a warranty deed.
Well, I'm assuming it was relied because at the time of this, I mean, there was the Treesback decision, there were decisions made. And subsequent to that decision is the Providence case, which deals with the same issues. That's a 1987 case. So that supersedes it. So a lot of these decisions supersede the Golden v. Hayes. And we have, I mean, I don't know how I can assume otherwise when it says we're dealing with recorded warranty deed and we're dealing with material consideration. And
Golden also has language regarding subsequent notice or notice to subsequent parties. And they seem to also emphasize that being a problem for a subsequent purchaser who doesn't pay attention to the fact that there's a corrective deed.
Well, in this case, with a quitclaim deed, if I might add, is if it's a corrective deed, the correction occurred in 2006 upon the filing because they're quitclaim deeds. And by the way, reformation, if you have a reformation, it relates back. They're all the cases deal with reformation and relate back in the same breath. Even the lower court determined reformation. But to your point is what's at the same, if you're going to do the constructive notice argument as to the Ellsbury, you also have the same constructive notice argument I mentioned before as to the Carpenters, because the same documents are of record as to whether or not there was ownership of the property at the time the easement was executed. So I believe what happens with the corrective deed in this case does not relate back, that the corrective deed conveys the land that's in that corrective deed and it's effective as of 2006. For the same token, if we're talking about when the reformation occurs is if the reformation occurs upon entry of the judgment in the lower court, then if we look at the case law, is that at that point in time is you have a reformation that's after the Ellsburys have owned the property, and then you have a situation that they're being adversely affected as well. So the argument works both ways, but I believe what we have here is because of the quitclaim deeds in love and affection, is the quitclaim deed categorized as a corrective deed. Just because it says corrective deed does not necessarily mean that it relates back, reforms, or does anything. Because of the nature of the deed and the consideration being only love and affection, we believe that in 2006, when the quitclaim deed was filed and recorded, that's when the conveyance occurred, and that's when the additional lands were acquired. If we just look at Golden v. Hayes and you rest your decision on Golden v. Hayes, then you don't rely upon every other case that was cited. You don't rely upon, then you ignore the Providence Square Association decision of the Supreme Court that was entered 14 years later. You ignore the Dro 15, all the subsequent ones in the progeny of Providence Square Association on a first district 1973 case, which on the record and on the face of the decision, you have a warranty deed and material consideration, which distinguishes that case from the subsequent Supreme Court case and the progeny dealing with what happens when you have a quitclaim deed out of love and affection.
Mr.
So-
Sperry, your time is up.
Can I
You
just make
your wrap up.
Okay, that's what I wanted to do. So based upon today's argument today, and we believe it's clear that the appellants request that this court reverse the lower court ruling and enter summary judgment for the appellants as to their count 1 and count 2, thereby finding the appellants own the lands described in the easement unencumbered by the Clark to Carpenter easement and free of the claims of the appellee. Thank you so much for your time, Your Honor, and entertaining argument.
Thank you both very much.
Thank you, Your Honors.
In order to leave our virtual courtroom, you need to click the button on your Zoom screen labeled leave, of all things, and you will go away. There you go. All right. Next case, I can't pronounce this one either. Duhamel versus Duhamel.